Stop everything. On September 10, 2025, the Department of Homeland Security announced a massive restructuring of U.S. citizenship and immigration services that will fundamentally change how every immigration application in America is processed, adjudicated, and decided. This isn't a minor organizational chart reshuffle. This is a complete overhaul that splits USCIS into two separate agencies, creates new processing standards, eliminates certain application categories entirely, and according to the administration, promises to cut processing times in half while simultaneously increasing enforcement and fraud detection. If you have any pending USCIS application, green cards, citizenship, work permits, visa extensions, anything, if you're planning to file an immigration benefit in the next year, or if you're an employer who sponsors foreign workers, what I'm about to tell you will directly impact your timeline, your chances of approval, and your entire immigration strategy. Stay with me for the next 30 minutes because I'm going to break down exactly what this restructuring involves. Whether the promised faster processing is real or just smoke and mirrors, who wins and who loses under the new system, and the 3 critical steps you need to take right now to protect your pending applications and plan for what's coming. Let me give you the background first, because understanding USCIS's current problems helps you evaluate whether this restructuring will actually solve anything or just create new chaos. U.S. Citizenship and Immigration Services is the agency within the Department of Homeland Security responsible for administering the nation's lawful immigration system. They process applications for naturalization, green cards, work authorization, asylum, refugee status, visa petitions, travel documents, essentially every immigration benefit that doesn't involve enforcement or border operations. USCIS is funded primarily through application fees, not through congressional appropriations, which means they're supposed to be self-sustaining. You pay $760 to file an N-400 naturalization application, $1,255 for an I-140 immigrant worker petition. That money goes into USCIS's budget to pay for officers, facilities, systems, and operations. The problem is that USCIS has been struggling with massive backlogs for years. As of early September 2025, before this restructuring was announced, USCIS had approximately 9 million pending applications and petitions across all categories. 9 million. Processing times have been increasing year after year. A green card application that used to take 8 months now takes 18 to 24 months. Naturalization applications that used to take 6 to 9 months now take 12 to 18 months. Work permit renewals that used to take 3 months now take 6 to 9 months, often expiring before renewals are approved. USCIS has blamed the backlogs on increased application volume, cybersecurity requirements, fraud prevention measures, and insufficient staffing. Critics have blamed poor management, outdated technology systems, inefficient procedures, and deliberate slow walking of applications during the Trump administration's first term. The September 10th announcement promises to fix all of this through what DHS Secretary Kristi Noem is calling the most significant modernization of immigration services in 50 years. Here's what the restructuring actually does. First, it splits USCIS into 2 separate agencies under the DHS umbrella. The first new agency will be called U.S. Immigration Benefits Administration, or USCIBA. This agency will handle what the administration calls presumptively approvable applications, essentially cases where the applicant already has significant ties to the United States and is applying for a benefit that's typically approved if basic eligibility criteria are met. This includes naturalization applications from green card holders, green card renewals, employment authorization renewals for people already in status, I-980 advance parole and travel documents, and certain family-based visa petitions where the relationship is clear and straightforward. The second new agency will be called U.S. Immigration Verification and Enforcement Services, or USCIS. This agency will handle what the administration calls high scrutiny applications, cases where there are potential fraud concerns, national security issues, or where the applicant doesn't already have established legal status in the United States. This includes initial green card applications from people adjusting status, asylum applications, employment-based immigrant petitions, H-1B petitions, other work visa petitions, applications from people with criminal histories or prior immigration violations, and any case that gets flagged for additional investigation during initial processing. Stated rationale for splitting USCIS this way is that it will allow USIBA to process straightforward cases quickly and efficiently without getting bogged down in complex investigations, while USIVES can focus resources on cases that require more intensive vetting. The administration claims this will dramatically reduce processing times for routine cases while improving fraud detection and enforcement for high-risk cases. They're projecting that USIBA will be able to process naturalization applications in 4 to 6 months instead of 12 to 18, and green card renewals in 2 months instead of 8 to 12. They're promising that employment authorization renewals will be processed within 30 days so people don't lose work authorization while waiting for renewals. But here's what they're not emphasizing in the press releases and what has immigration attorneys extremely concerned. USCIS, the enforcement-focused agency, will have significantly more aggressive adjudication standards than USCIS has historically used. The September 10th directive establishing USCIS includes language instructing officers to rigorously apply all statutory and regulatory eligibility requirements, to thoroughly investigate any potential fraud indicators, and to deny applications rather than issue requests for evidence when initial filings are incomplete or insufficient. This is a massive shift from current practice, where USCIS generally issues requests for evidence, giving applicants opportunities to cure deficiencies in their applications. Under the new USCIS approach, if your application isn't perfect and complete on initial filing, it can be denied outright. You lose your filing fees, and you have to start over. Second major change. The restructuring eliminates certain application categories that the administration views as inconsistent with restrictive immigration priorities. Specifically, the directive announces that effective January 1, 2026, USCIS will no longer accept I-131 applications for travel documents for people in removal proceedings. Will no longer accept I-601 applications for waivers of certain grounds of inadmissibility in removal proceedings, and will significantly restrict I-212 applications for permission to reapply for admission after deportation. The administration argues these applications allow people who are subject to removal to delay their deportations or circumvent enforcement, and that immigration judges in removal proceedings should handle these issues rather than USCIS adjudicating them separately. Third major change. The new structure creates something called priority processing tiers for USCIS applications. Tier 1 applications, those from individuals with advanced degrees from U.S. universities, individuals sponsored by large established companies, individuals in fields designated as national priorities, like artificial intelligence or semiconductors, and individuals with no criminal history or prior immigration violations, get assigned to dedicated adjudication teams and receive target processing times of 6 to 9 months. Tier 2 applications, everyone else going through USIVS, gets standard processing with target times of 12 to 24 months. And Tier 3 applications, those with complicating factors like criminal histories, prior visa overstays, or applications from small companies with limited track records, go into what's essentially a slower review queue with no guaranteed timeline. Now, let me walk you through what this means in practice with some concrete examples. Ahmed is a 35-year-old green card holder who's been a permanent resident for 6 years. He's applying for naturalization. Under the current system, his application goes to USCIS, gets assigned to a field office based on his residence, and he waits 12 to 18 months for his interview and oath ceremony. Under the new system, starting in January 2026, when the restructuring is fully implemented, Ahmed's application goes to USIBA, the Benefits Administration Agency. Because naturalization for established green card holders is considered presumptively approvable, his case gets processed in the faster track. He could potentially get his interview within 4 to 6 months and take his oath within 7 to 9 months total. For Ahmed, this restructuring is actually beneficial. Faster citizenship, less waiting, same eligibility standards. But now consider Yuki. She's from Japan. She's been working in the US on an H-1B visa for 3 years, and her employer is sponsoring her for a green card. Her employer filed the I-140 immigrant petition in August 2025, before the restructuring. Under old USCIS processing, that I-140 would take about 6 to 9 months to get approved. But because the petition is still pending when the restructuring takes effect in January 2026, it gets transferred to USCIS, the enforcement-focused agency. USCIS reviews the petition under the new, rigorous standards and decides the labor certification documentation isn't sufficiently detailed. The employer's recruitment records don't conclusively prove they couldn't find qualified U.S. workers. Under old USCIS practice, they'd issue a request for evidence, giving the employer 30 days to submit additional documentation. Under new USCIS practice, they just deny the petition. Yuki's employer has to start over, file a new petition with more extensive documentation, pay the filing fees again, and wait another 12 to 24 months for a decision. For Yuki, the restructuring is catastrophic. We just walked through how Ahmed benefits from the restructuring while Yuki gets devastated by it. And now, we need to talk about the massive disruption this is causing to pending applications right now, and what the real agenda behind this reorganization actually is. Let me give you another scenario that illustrates the chaos that's already starting, even before the restructuring is fully implemented. Marcus is a software engineer from Kenya who's been in the United States on an H-1B visa for 5 years. His H-1B is expiring in December 2025, and his employer filed an extension petition in September, well before the expiration date. Under normal USCIS procedures, Marcus would receive a 1-year extension based on the timely filed extension petition, even if the petition isn't adjudicated before his current H-1B expires. This is called the cap-gap extension or automatic extension based on a pending petition, and it's been standard practice for decades. But now, with the restructuring happening in January 2026 and Marcus's extension petition being transferred to USCIS mid-processing, there's enormous confusion about whether he'll receive the automatic extension or whether USCIS will apply different standards that might deny his extension or delay it past his expiration date. Marcus's employer is panicking because they can't afford to lose him. And Marcus is terrified because if his status expires and he doesn't get the extension, he becomes unlawfully present and could face bars to future immigration benefits. This is general information, not legal advice, but you need to understand that the transitional period between now and full implementation of the restructuring in January 2026 is going to be absolute chaos. USCIS has announced that all pending applications as of January 1st will be reviewed to determine which agency they should be transferred to, USCIS or USCIS. That means potentially millions of pending cases will be physically or electronically moved between systems, reassigned to different adjudication teams, and potentially subject to different processing standards. Anytime you have a massive reorganization like this, cases get lost, files get corrupted, processing stops completely during the transition, and timelines extend dramatically. Even though the stated goal is to reduce processing times, immigration attorneys across the country are reporting that they're already seeing impacts, even though the restructuring doesn't officially take effect until January. USCIS appears to be slowing down adjudications of certain case types in anticipation of the transition, presumably to avoid having to transfer cases mid-adjudication. Some attorneys are reporting that cases that would normally have been approved by now are sitting in limbo with no updates. Others are reporting that USCIS is issuing more requests for evidence than usual, possibly trying to clear questionable cases before the transition so they don't become USCIS problem. The whole system is basically frozen in anticipation of this massive change. Now let's talk about what the real agenda is here. Because the administration's stated goals of faster processing and better fraud detection are only part of the story. The unstated but obvious goal is to make it significantly harder to get initial immigration benefits, while making it easier to maintain status once you already have it. Think about the logic. If you're already a green card holder applying for citizenship, the new system helps you, USIBA, faster processing, presumption of approvability. If you're already a green card holder renewing your card, the new system helps you. If you already have work authorization and you're just renewing it, the new system helps you. But if you're trying to get your first green card, if you're trying to get your first H-1B visa, if you're trying to adjust status from undocumented to legal, the new system creates massive new barriers. USCIS, enforcement focus, rigorous standards, no requests for evidence, tier-based processing that discriminates based on your profile. This is a system designed to benefit people who are already established in the legal immigration system, while creating choke points that make it much harder for new people to enter. From the administration's perspective, this achieves their restrictionist immigration goals, while allowing them to claim they're actually making the system more efficient for people who follow the rules. It's politically savvy because people who already have status will see faster processing and will be satisfied, while people trying to get initial status will face obstacles, but they're not yet part of the U.S. electorate, so their complaints carry less political weight. P. Let me give you a third scenario that shows another dimension of this. Sophia is from Brazil. She overstayed a tourist visa 10 years ago, but she married a U.S. citizen 5 years ago and has 2 U.S. citizen children. Her husband filed an I-130 petition for her. It was approved, and she's now ready to file I-485 to adjust status to permanent residence. Under current USCIS practice, she'd file her adjustment application, and she'd likely be approved despite the prior overstay because she has the waiver available through her U.S. citizen spouse, and she'd get her green card in about 12 to 18 months. Under the new system, her I-485 goes to USCIS because it's an initial green card application. USCIS applies the rigorous standards, sees the prior overstay as a fraud indicator, or at least as a negative factor, categorizes her as Tier 3 because of the complicating immigration history, and her case goes into the slow processing queue. Even though she's legally eligible for adjustment and has approved waivers, her processing time could stretch to 24 to 36 months. And she faces increased risk of denial if USCIS decides to interpret regulations strictly against her. The American Immigration Lawyers Association held an emergency meeting on September 15th to discuss the restructuring, and the consensus among immigration attorneys is that this is one of the most significant policy changes they've seen in decades. AILA is already preparing litigation challenging multiple aspects of the restructuring. They're arguing that creating 2 separate agencies with different adjudication standards for the same statutory benefits violates equal protection principles. 2 people applying for the same green card category should be judged by the same standards, not different standards depending on which agency happens to adjudicate their case. They're arguing that eliminating certain application categories without going through proper rulemaking procedures violates the Administrative Procedure Act. And they're arguing that the tier-based processing system that explicitly prioritizes applications from people with advanced U.S. degrees and big company sponsors discriminates against applicants based on national origin and economic status in violation of federal civil rights laws. But litigation takes years, and in the meantime, this restructuring is happening, and everyone with pending or planned applications has to navigate it. Let me walk you through what's actually changing in terms of specific application types, because understanding the details helps you strategize. For naturalization applications, the news is mostly good. These are moving to USIBA. Processing times should improve, and standards aren't changing much because naturalization eligibility is clearly defined in statute. If you're a green card holder who's had permanent residence for 5 years, or 3 years if married to a U.S. citizen, and you meet the other requirements, you should see faster processing under the new system. For green card renewals and replacement cards, again, the news is good. These are USIBA applications, should process much faster. The administration wants to avoid situations where people have expired green cards for years while waiting for renewals, because expired cards create problems for employment verification and travel. For employment authorization renewals for people who already have work permits, there's a commitment to 30-day processing, which would be a massive improvement over current 6 to 9 month processing times. But there's a catch. If anything in your renewal application triggers a fraud concern, or if your underlying status has any complications, your renewal could get kicked over to USCIS for full investigation. And then you're looking at months of delay despite the promised 30-day processing. For initial green card applications, whether family-based or employment-based, this is where the major negative impacts hit. All of these go to USCIS. The priority processing tiers mean that if you're from India or China, where there are massive backlogs and you're not in a priority field, you're automatically Tier 2 at best. If you have any complicating factors, a prior visa denial, gaps in your legal status, previous unlawful presence, minor criminal history that's been resolved, you're Tier 3 and facing extremely slow processing and heightened scrutiny. The elimination of routine requests for evidence means that if your initial I-485 adjustment application doesn't include absolutely every piece of required documentation perfectly formatted and explained, you could get an outright denial instead of an opportunity to supplement your application. For H-1B petitions, L-1 petitions, and other non-immigrant work visas, these are all USCIS applications subject to rigorous review. The administration has made clear they view the H-1B program as rife with fraud, and they want USCIS to crack down. Immigration attorneys are expecting H-1B denial rates to increase significantly under USCIS compared to current USCIS practice. Small and medium-sized companies that don't meet the established large company criteria for Tier 1 processing will face longer waits and higher denial rates. Consulting companies and staffing agencies, which have historically been major H-1B users, are likely to see their approval rates plummet because USCIS will apply strict site control and employer-employee relationship requirements that these business models often struggle to satisfy. For asylum applications filed affirmatively with USCIS, meaning asylum applications filed by people who are not in removal proceedings, these go to USCIS and face the toughest scrutiny. The administration has stated that all asylum applications should be presumed potentially fraudulent unless proven otherwise, which is a complete reversal of traditional humanitarian protection principles. Asylum approval rates, which were already declining under Trump administration policies, are expected to drop even further. Processing times for asylum interviews are expected to increase even as the administration claims to be speeding up the system overall, because asylum cases are deprioritized compared to economic immigration cases. For special immigrant categories, things like special immigrant juvenile status for abused or abandoned children, U visas for crime victims, T visas for trafficking victims, VAWA self-petitions for domestic violence victims, these go to USCIS, but theoretically should receive more sympathetic adjudication because they involve vulnerable populations. However, attorneys who work in these areas are concerned that USCIS enforcement mindset will lead to increased scrutiny and skepticism, even in humanitarian cases. There are already reports of USCIS in recent months issuing more requests for evidence in VAWA cases, questioning whether abuse really occurred, and attorneys fear this will get worse under USCIS. Let me start by addressing the single most important strategic question everyone is asking. Should you rush to file your immigration application before January 1st, 2026, when the restructuring takes full effect? Or should you wait and see how the new system actually works? The answer depends entirely on what you're filing and what your specific circumstances are. If you're filing a naturalization application and you're eligible now, there's less urgency because naturalization is going to the faster USIBA agency regardless. You might actually benefit from waiting until the new system is in place and processing times improve. But if you're filing an initial green card application, an H-1B petition, an adjustment of status application, or anything that's going to USIVS, you face a difficult calculation. Filing now under the old USCIS system means your application will be processed under current standards that are generally more forgiving. They'll issue requests for evidence if your application has deficiencies. They'll give you opportunities to supplement documentation, and denial rates are lower. But your application will also be caught up in the transition chaos. It might get transferred mid-processing to USIVS, and there's no guarantee it'll be adjudicated before the new system takes effect. Filing after January under the new USIVES system means you face the stricter adjudication standards. No RFEs for incomplete applications. Queue-based processing that might delay your case, but at least you're working within a defined system rather than caught in transition limbo. Immigration attorneys are generally advising clients who are ready to file and who have strong, well-documented cases to file immediately. Get your application into the system before the transition. Get a receipt notice establishing your filing date and priority. And hope it gets adjudicated quickly, or at least that you get grandfathered under old adjudication standards. But if your case has any complications, if you're missing critical documents, or if you need more time to prepare a bulletproof application, some attorneys are advising to wait. Use the next 3 months to build the strongest possible case, and then file under the new system with everything perfectly documented, so you don't give USCIS any excuse to deny. Now, let's talk about the 3 critical steps you must take immediately, whether you have a pending application or you're planning to file. Step 1. If you have any application pending with USCIS right now, contact your immigration attorney or file a case status inquiry to find out exactly where your case stands and which agency it will be transferred to when the restructuring takes effect. You need to know whether your case is close to adjudication or whether it's likely to sit in limbo during the transition. If your case is with USCIS now and it's in a category going to USIBA, you're probably in decent shape. Just monitor it and make sure the transfer happens smoothly and your receipt date is preserved. If your case is going to USIVS, you need to assess whether there are any weaknesses or deficiencies that might lead to problems under the stricter standards. This is the time to proactively submit additional evidence even if you hadn't received an RFE, because once the case transfers to USIVS, you may not get another opportunity. If you have a work authorization document or travel document that's expiring between now and mid-2026, file your renewal application immediately, even if you're still within the normal filing window. Do not wait until the last minute, because processing during the transition period is completely unpredictable. File as early as USCIS allows, typically 180 days before expiration for EADs, and if you don't receive approval before your document expires, make sure you have documentation of your timely filed renewal that provides you automatic extension of work authorization while the renewal is pending. Keep copies of your receipt notice, your expired EAD, and any notices from USCIS in case you need to prove to employers or border officials that you have continuing authorization. Step 2. If you're planning to file any immigration application in the next 6 to 12 months, consult with an immigration attorney right now to develop a strategic timeline. Do not try to navigate this transition on your own. An experienced attorney can evaluate your specific situation, tell you whether you should file immediately or wait, help you understand which agency will handle your case, advise you on what documentation standards you need to meet, and prepare your application to withstand the stricter use of scrutiny if that's where you're headed. Different attorneys will have different strategic approaches based on their experience and their assessment of how the transition will play out. So it's worth consulting with more than one attorney if you can afford it to get multiple perspectives. For any application going to USCIS, you need to assume that your initial filing must be absolutely perfect. That means gathering every piece of required documentation before you file, not after you get an RFE. Birth certificates, marriage certificates, divorce decrees, police clearances, medical exams, financial documents, employment letters, tax returns, proof of relationship, proof of residence. Everything needs to be included in your initial package. Documents in foreign languages need to be translated by certified translators with proper certification statements. Photographs need to meet exact specifications. Forms need to be filled out completely, with no blanks, unless the question genuinely doesn't apply to you. Any explanation of complicated circumstances needs to be included upfront in detailed affidavits or cover letters. You're essentially assuming USCIS will not give you a second chance to fix anything, so get it right the first time. Step 3. Prepare financially and logistically for longer processing times and increased costs, even if the administration promises faster processing. The reality is that major system overhauls always cause delays in the short to medium term, even when they eventually improve efficiency in the long term. Budget for the possibility that your green card application might take 24 to 36 months instead of 12 to 18. Budget for the possibility that you'll need to pay for premium processing if it's available for your case type. Budget for higher attorney fees because preparing bulletproof applications that can withstand USCIS scrutiny takes more attorney time. Budget for the possibility that your application might be denied and you'll need to appeal or refile. And prepare logistically for what happens if your status expires while applications are pending. Do you have backup plans for maintaining legal status, for continuing to work legally, for staying in the U.S.? If your primary application is delayed, let me address what's happening with USCIS staffing and infrastructure, because that's a critical part of understanding whether this restructuring will actually work. The September 10th announcement includes plans to hire 3,000 additional adjudication officers over the next 18 months. 1,500 for USIBA and 1,500 for USIVES. That's about a 20% increase in adjudication staff, which sounds significant. But USCIS has been trying to hire more officers for years and has struggled with recruitment and retention because government salaries can't compete with private sector opportunities for people with the skills needed to adjudicate complex immigration cases. Even if they succeed in hiring 3,000 new officers, training them takes 6 to 12 months. So we're not going to see the benefit until late 2026 at the earliest. The restructuring also requires massive IT system changes. USCIS will need to build or modify case management systems to handle the split between USIBA and USIVs, to implement the tier-based processing for USIVs cases, to track which cases are presumptively approvable versus high scrutiny, and to ensure that case files can be transferred between agencies when needed. Anyone who's dealt with USCIS's current online systems knows they're already buggy and outdated. The idea that they're going to successfully implement a major systems overhaul while simultaneously reorganizing the entire agency and continuing to process 9 million pending cases is frankly laughable. We should expect significant technology problems, system outages, lost files, and processing delays related to IT issues. There's also the human factor. USCIS officers who've been adjudicating cases for years under one set of standards and procedures are now being told they're being reassigned to either USIBA or USIVES, with different missions and different standards. Some officers will be moving to USIBA, where the emphasis is speed and efficiency, presuming cases are approvable, unless there are obvious problems. Other officers will be moving to USIVES, where the emphasis is thorough investigation and rigorous standards, presuming cases are potentially fraudulent unless proven otherwise. This requires a complete shift in mindset and approach, and it's going to take time for officers to adjust. In the transition period, we should expect inconsistent adjudications, confusion about which standards apply, and decisions that don't make sense because officers are caught between old and new procedures. Let me talk about the broader implications of this restructuring beyond just the immediate impacts on pending cases. What we're seeing is the creation of a two-tier immigration system that explicitly advantages certain types of applicants over others based on factors that have nothing to do with their legal eligibility. The priority processing tiers mean that someone with a PhD from MIT applying for a green card through a Fortune 500 company gets Tier 1 treatment. Fast processing. Presumption of approval. While someone with a bachelor's degree from a foreign university applying through a small company gets Tier 2 or Tier 3 treatment. Slow processing, heightened scrutiny. Both applicants might be equally eligible under the statute, but they're treated differently based on pedigree and employer profile. This is a fundamental shift from equal treatment under law toward an explicitly hierarchical system, where your immigration application is judged not just on whether you meet legal requirements, but on whether immigration authorities view you as a high-value applicant. It's essentially importing the points-based immigration systems used by countries like Canada and Australia, but doing it through executive agency restructuring, rather than through congressional legislation that would allow for democratic debate about whether this is the kind of immigration system Americans want. The restructuring also represents a massive expansion of enforcement mentality into what was traditionally a benefits-granting agency. USCIS has always had a fraud detection mission, but it was balanced with a service mission, helping people who are eligible for immigration benefits actually receive those benefits. The creation of USCIS as a separate agency with an explicit enforcement focus means that half the immigration adjudication system will be operating from a presumption of skepticism, rather than a presumption of good faith. This is going to change the entire culture of immigration adjudication, making the process more adversarial and more hostile to applicants. Here's the legal disclaimer. This is general information about the announced USCIS restructuring as of September 2025. This is not legal advice, and it's not a substitute for consulting with a qualified immigration attorney about your specific case. The restructuring is still being implemented. Regulations and procedures will continue to change, and every individual situation is unique. Immigration law is complex and constantly evolving, and you need personalized legal guidance to navigate these changes successfully. Let me leave you with this final message. We are witnessing a transformation of America's legal immigration system that will affect millions of people over the coming years. Some people, those already established with legal status, those with advanced degrees and prestigious employers, those applying for straightforward benefits, may see improvements in processing times and efficiency. But many others, those seeking initial status, those with complications in their histories, those from certain countries or working for certain types of employers, will face new barriers, longer waits, and increased risk of denial. This restructuring is being sold as modernization and efficiency. But make no mistake, it's also a tool for restriction and enforcement. If you're navigating the immigration system, you need to be strategic, proactive, and extremely careful in how you prepare and file your applications. The old approach of filing a minimally compliant application and responding to RFEs is not going to work anymore. You need to front-load all your evidence, anticipate all potential issues, and prepare applications that can withstand hostile scrutiny. If this video has helped you understand what's coming and how to prepare, hit that like button right now. Subscribe to this channel for continuous updates on this restructuring as implementation details are released, and as we see how it actually works in practice. Share this video with anyone who has immigration applications pending or planned, because this information could literally change the outcome of their cases. Your legal status is an ongoing responsibility. The immigration system is changing dramatically, and you need to stay informed, stay prepared, and get professional help to navigate these changes. This is too important to leave to chance, and this is too important to try to handle on your own. Take action now while you still have time to strategize and prepare.